proceed.
May it please the court. Jane Kreusler-Walsh here on behalf of the appellant John Goodman, petitioner below. With the court's permission, I'd like to reserve 5 minutes for rebuttal. With me is my associate, Stephanie Sarandon. We are here today presenting two rule challenges. First, it's our position that the blood collection rule is invalid. It's invalid because the FDLE lacks the delegated legislative authority to regulate blood collection. Secondly, the blood collection rule and the blood analysis rule are inadequate because they fail to ensure the scientific reliability of the test results.
That's an alternative argument.
Yes,
right?
that's
Okay.
exactly
So on the
correct.
first argument, I guess there's four parts to the process. There's the pre-part with the rub of the gauge, the non-alcoholic swab, and also determining if he's been drinking since the accident, those kind of things. The second part is the blood draw. The third part is the preservation, I guess, of the blood, and the fourth part finally is the testing. There's bouts. And I guess in the Miles case, the Supreme Court's determined that the preservation of the blood is part of the testing process, correct?
Correct.
Okay, so your argument is either that the collection, that the draw itself is not part of the process, or if it is, the rules are incomplete to preserve the validity of the sample.
Are you asking me about our first issue, Your Honor, or our second issue?
Right, so your first issue would be, preservation is part of the testing per Miles, but not the draw?
Our first issue is that there is nothing in the implied consent statutes that gives the FDLE the authority to enact a rule that regulates blood collection.
Well,
That's our first issue.
Yeah, but on that one, isn't the better position on the other side? Because in fact, that's what you say, that the blood collection is central to the validity of the test.
It's a different argument, Your Honor. They're entirely different. If you look at the implied consent statutes, there really and truly is nothing in the implied consent statutes that gives the FDLE the authority to regulate, to enact a rule that regulates blood collection.
What they say is, like in 19321A20, it says, have authority to specify techniques and methods for blood testing utilized under the driving and voting under the influence provisions. Okay. In Miles, they talked about, because there was evidence in this case where they say the state and the defense both admitted in that case that drawing, preservation, maintenance, and they used drawing. Now, they weren't
Correct.
talking about drawing in that case, but they said drawing was essential to the validity of all those tests.
Correct.
Now, why, even though they didn't actually decide it in that case, why wasn't that? I mean, why would we think that when they say testing, isn't testing a broad word that covers from beginning to end, because they're all part of the process?
Testing is something that is inherent to the process, but let me remind you, in Chapter 120, there is specifically, in 125.8.8, there's specifically part of the statute that says, no agency shall have the authority to adopt a rule only because it reasonably relates to the purpose of the enabling legislation, which is exactly what collection does. It is a rule that reasonably relates to the purpose of the enabling legislation. There is nothing, respectfully, in the implied consent statutes that gives the FDLE the authority to enact a rule regarding collection. I agree with you that collection.
But I guess it depends upon whether testing is used in its broad sense or its very, very limited sense. Because if it is, then you may be, if it's only delimited for when the person gets that sample and puts it through whatever they're going to do when they actually, stir it up and do those things, then all the other stuff is not within their authority either.
I agree with you. Does it reasonably relate? Does it make sense? I agree with you 100%.
Well,
It
I'm
does.
saying it's part of testing because it's an integral. Testing doesn't. Well, maybe you're right.
I would rather not waste my time this morning arguing that issue with you. And I'd rather move on to point 2.
Okay.
And discuss that.
Could I
Because
just
it
ask
is.
one more question on that?
Yes, Your Honor.
If we were to side with you on your first argument.
Yes.
What would be the remedy?
The ramifications of that would be, it would be up to the legislature to enact a statute.
What would be the remedy in this case, though?
The remedy in this case would be reversal and remand for the, it would be reversal and remand for, to go back to the trial court to decide the ramifications of this in the criminal trial.
If they didn't have the authority to regulate, and we think this is regulation, or if it, and they were in fact regulating, it all has to do with whether they would get a presumption. It doesn't mean that in a criminal trial the state couldn't prove
Yes.
an unlawful. It's just that you don't get the presumption.
Yes.
Is that correct?
That is correct. That is correct. And my not being a criminal defense lawyer, I don't feel qualified to say to you what the ramifications of that would be.
Right, I understand.
That is not my field. But let's talk about point 2. Our argument on point 2, and let me first say that we are accepting all of the administrative law judge's factual findings for the purposes of our argument here today. I am not going to argue anything that relates to hemolysis. My arguments are going to be limited solely to clotting. And it is important to say first that the administrative law judge found that the type and size of the needle causes clotting, can cause clotting. He also found that the type and size of the needle may cause an increase in the alcohol content. What he then found, however, was that even though the type and size of the needle may increase the alcohol content, that it had to inevitably, using his words, preclude the withdrawal of an inappropriate subsample. That, Your Honors, is an inappropriate conclusion, and that, Your Honors, requires reversal. And that is because of the Supreme Court's holding in Miles. In Miles, the Florida Supreme Court adopted the Supreme Court's ruling in State v. Bender. And in State v. Bender, that's where the Supreme Court had the ensuring the reliability of the test results. That's where the implied consent statute first came about, and that's where the ensuring the scientific reliability of the test results came about. And in State v. Miles, that's where the court was dealing with the refrigeration results. And the Supreme Court there, in words almost identical to the administrative law judge here, said that lack of refrigeration for 14 days may well have impacted the integrity of the blood sample. Here we have the administrative law judge. Let me get to the findings. Paragraph 49. May result in elevation of the blood alcohol level. The exact same words. Let's go back to Miles. Miles says that the lack of refrigeration may well have impacted. The may well have impacted. The court says, finds, because of that, it renders Rule 11D 8.0123 inadequate and inconsistent with the purpose of the implied consent rule as it relates to ensuring the reliability of the test results. Compare that with the administrative law judge here, who says, and I quote, that the evidence fails to establish that the mere presence of coagulation inevitably precludes the withdrawal of an inappropriate subsample. That is reversible error, and that requires that this case go back.
In other words, the ALJ said in order to succeed, you have to show that this essentially absolutely would affect the blood trim. Not, and where you're saying is that Miles says it's not that high.
That's exactly right.
It's a, I don't know, is it more likely than not, or is it, what do you think may affect Possibly.
I think that's all that Miles is saying.
Do you
May well
think-
have impacted.
I mean, I don't know, that didn't appear in Miles that there is any type of testimony as to scientifically, is this within the margin of error? I mean, would we have to have testimony that it was within the margin of error, that it would not affect the blood test?
Well,
I mean,
actually,
every scientific test has a margin of error.
right, that's true. And actually here, we have testimony from the FDLA's expert, Dr. Goldberger, that clotting can increase the alcohol level by as much as 15%. We have testimony from their expert. We have testimony that clotting, if a sample is clotted, it needs to be, that clotted sample needs to be rejected. That clotting, in his words, that clotting affects the scientific reliability of the sample. These are his words. I mean, that, you know, you need that the collection techniques are of paramount importance. Dr. Goldberger, their expert, was the best witness for us. It's impossible in this case to reject to take the administrative law judge's factual findings and get to the conclusion that he got to. It's just legally impossible. And then when you get to the next level, when you get to 8.013 and that rule, and once again, Dr. Goldberger's findings, you're now looking at screening for irregularities, documenting those irregularities, and then rejecting compromised samples.
Well, Counsel, even in the findings in paragraph 49, the ALJ talks about the subsample being taken, and so isn't this basically something that comes from the actual findings taken at this particular hearing, and if in fact you could get an appropriate reading from the subsample, doesn't that cure this and also Miles as well?
No, Your Honor.
As well.
Because when you read Dr. Goldberger's testimony, Dr. Goldberger said himself, the FDLE's expert, so much of what happens with a particular sample depends upon the training of the particular analyst who's doing the test. That doesn't ensure the scientific reliability of the test. It has to be across the board. It can't be based on a particular analyst who's doing the test. It can't be. And remember, we are dealing with due process concerns in a criminal case. And we're dealing with people who need to be able to document test results. And we're dealing with labs across the state of Florida who right now have no requirements that they screen for irregularities, that they document those irregularities, and that they reject compromised samples. And as I was getting to a moment ago, we have the FDLE's experts saying that in his labs, the gold standard is that they have to do all of those things, but that the FDLE's own person, Mr. Patrick Murphy, who testified, said that the good laboratory practices don't require any of those things. The only thing that good laboratory practices require is what's in the FDLE rules. And those FDLE rules don't require any of those things. So it's our position that the FDLE's expert, Dr. Goldberger, his testimony establishes what needs to be in those rules. And those rules should require screening for irregularities, documenting for irregularities, and rejecting compromised samples.
Okay.
That's what should be in them. And I'd like to reserve the 49 seconds that I have. Thank you.
Good morning. May it please the court, my name is Anne Marie Johnson, and I represent the Florida Department of Law Enforcement's alcohol testing program. The issue in this case is whether the evidence established a basis to invalidate Administrative Rules 11D8.1 11D8.012 and 11D8.013. And the record is clear. There is no basis in which to invalidate these rules.
Well, let's start first about, you're taking the position that FDLE doesn't have the authority to regulate blood collection. But 102 is first titled something about blood labeling and blood collection, and it regulates what happens before it. The needles go in the arm or whatever, and after it's out.
Correct,
It
Your Honor.
doesn't
We don't
go
have
in
the-
between? I mean, is that,
They don't
what
have-
part is called blood
They
collection
don't have
in
the
this part?
delegated legislative authority to rule the blood collection procedures and unless it affects the accuracy and reliability of the sample.
Okay, but you say it doesn't have the blood collection procedures, but you tell your own rule says, before you draw the blood, you have to do this.
Right,
Is that
because
part of
that
the blood
affects the
collection, but that's a part of the test?
Because that affects the accuracy and reliability of the sample.
So you're saying that anything, you can and have the authority to regulate anything that can impact the reliability of the sample going forward?
Correct,
Okay,
pursuant to
well,
316.19.
doesn't Miles, I mean, they don't say it, but they quote all the testimony in there that the state and the defendant in that case both agreed that the entire process was essential. They happen to deal in that case with the preservation, but they say in that case, drawing, preservation, maintenance, and the testing and the procedures. They use drawing, which
Correct.
is what we're talking about here.
Miles is distinguishable because Miles was not a challenge to the validity of the rule. This was part of the appellate process on a criminal trial's motion to suppress. So this was not an attack on the validity of the rule. This was only to determine the admissibility of the presumptions. This wasn't, none of the Miles
Well,
Robertson.
it does say adequacy of Rule 11D812, so
Right,
they
but
were-
this wasn't
they
an
decided it was
administrative
not
challenge. Miles wasn't the result of an administrative challenge to the rule. It was pursuant to a motion to suppress filed in the criminal case. So in this case,
Right.
they didn't have the authority to invalidate the rule in this particular case. This was just to determine whether or not the state was entitled to the presumptions.
But obviously, what happened after this case is that they redid the rule.
FDLE did change the rules because we wanted to assist the state in being entitled to the presumptions. The
And
Florida
then-
Department of Law Enforcement wasn't told the rule is invalid and you need to change it. It was FDLE took it upon themselves to change the rule in response to Miles so that the state would be able to use the presumptions.
Well, okay, I was discussing with the appellant the fact that what does testing mean, and doesn't testing mean the whole thing? And I mean, in one sense, your rules say that testing means the whole thing, because you're going to start by doing a rule that says you have to use ethanol as opposed to alcohol when you're before you stick the needle in.
Right, but that's, we only have authority to regulate what affects the accuracy and reliability of the sample.
Isn't the argument that by not regulating the size of the needle or the tourniquet approach, that gives a greater possibility of clotting, and I guess, and the extension of that is clotting cause, and they've conceded on it on hemolysis, but I guess the concentration on clotting, that clotting gives a greater possibility of
Well, I think the record
affecting the
is very
sample.
clear in that the procedures in which the appellant would like included in the rule, the needle gauge and tourniquet use, do not affect the accuracy and reliability of the sample.
But they
Even the
affect the
administrative law-
propensity to clot, correct?
That's to do with hemolysis, clotting, hematocrit levels. The judge actually said, as Your Honor stated, in the order on what was number 49, that clotting does not affect the blood alcohol testing if the sample itself, the subsample taken from the tube, was actually representative of what was in the person's system, the whole blood sample. So when clotting occurs, the sample can be homogenized, which is basically stirred, that restores it to uniformity. So clotting doesn't actually affect the blood alcohol analysis result.
And is that safeguarded by the processes that are set out in the rule? I think there's certain things that are in the tube,
Correct, there's an anticoagulant and a preservative in the tube. And the standard operating procedures of each lab do include what to do if you have a clotted sample. The standard operating procedures are not necessary to be included within the rule.
Wait a minute, here's what that says. The evidence establishes that coagulation in a sample may result in elevation of the blood alcohol level reported by a subsample subjected to gas chromatography, headspace analysis. However, the accuracy of a blood alcohol test report derived from a sample that exhibits coagulation depends upon whether the subsample taken from the sample is an appropriate representation of the components of the whole blood contained in the collection tube. The evidence fails to establish that the mere presence of coagulated blood in a sample inherently precludes the withdrawal of an appropriate subsample.
So even if there's clotting present, you can still obtain an accurate subsample.
But does that, I mean, but since it does affect the blood alcohol level, then shouldn't the FDLE have some regulations to make sure that doesn't happen? You just said we have the authority to regulate things that affect the accuracy of the test. They've just said that coagulation can affect, or clotting can affect the accuracy of the test. So isn't that something that you should regulate?
I don't believe that that's what they're saying. That's what the administrative law judge is saying. He's saying the accuracy is dependent on whether or not that subsample is an appropriate representation of the components of the whole blood.
Well, how do we know that it is? I mean, how shouldn't there be a rule to make sure that subsample is, whether it's shaken or stirred or whatever they have to do to
Homogenized, correct.
get?
And that's included in the standard operating procedures. You can still have an accurate and reliable result from a subsample that's not affected by clotting. The clotting doesn't affect the accuracy and reliability of the result. It may affect the ability to obtain a subsample. If the blood is so clotted that you can't accurately obtain a subsample, then your sample, you wouldn't be able to obtain a sample for analysis.
Is there anything, but I mean, obviously that's so clotted, but on the other hand, there could be some that are less clotted but still significantly
Right, and those can be homogenized, stirred to restore it to uniformity.
Well, how do you know? I mean, how
Because
do
it's included in this lab standard operating procedures.
So I guess the argument is these things are common sense. You don't need to regulate common sense.
Correct, Judge. Exactly.
Well, Counsel, though, isn't part of the argument, though, that your over-regulation has caused a problem by possibly preventing more accurate methods to be used by the local labs and collectors?
We don't consider it over-regulation. These are things that the court in Miles had said, these affect the accuracy and reliability of the sample. You have the delegated legislative, FDLE has the delegated legislative authority to regulate the sample to ensure that you're producing accurate and reliable results. So FDLE needed to make rules regarding the things that affected the accuracy and reliability of the results. So that's why it was amended.
As your opponent pointed out in section 120.52.8, the statute says that no agency shall have the authority to adopt a rule only because it is reasonably related to the purpose of the enabling legislation. And by going in like that, it has the effect of having the other consequences, such as the presumptions and whatnot, that could be litigated in a different manner.
Well, 316.1932, 182, and 1F1 gives the Florida Department of Law Enforcement the delegated legislative authority to regulate that which affects the accuracy and reliability of the test. So I don't believe that it's over-regulating It's necessary, and the Miles Court found it necessary in order to ensure the accuracy and reliability of the result.
You know, I look at some of these cases like, this is what we lawyers and judges deal with, scientific things, and we're trying to figure these out, and none of us had this background, but somehow it all comes to our court. So I'm going to try this again. Because I have a hard time with the clotting thing. Clotting can affect the blood level, the blood alcohol level. So therefore, it is something that can affect the accuracy and reliability of the test.
No, I don't believe so. The clotting does not affect the accuracy and reliability of the result. It affects the ability to obtain a sample. So if the blood is so clotted that you're not able to obtain a sample that's representative.
Well, but the experts said that clotting can increase the blood alcohol level by up to 15%. Obviously,
He said,
he's
and that was, Judge, that was an important determination, is he said that in regards to when you're testing serum blood, and FDLE's rules prevent you from testing serum blood. The FDLE's rules specifically state that only whole blood is to be tested. When you're testing serum blood, which is usually done in a clinical setting, that's when the blood alcohol result can be 15% to 18% more. That's only when testing serum blood, not whole blood. And for forensic purposes in the state of Florida, we only test whole blood.
Okay.
So there's no particular, there's nothing in the rules themselves saying don't test the clotted portion of the blood. And that's, the state's argument is, well, that's common sense. It's
Correct,
standard
Judge.
operating
That's
procedures.
common sense. There isn't a lab that's going to test
Although
or attempt to
you
take
do
a
regulate testing, so that could be a part of the testing, clearly.
Well, it's not a part of the testing as much as it's preparation, and we can't include every single standard operating procedure in the rule, because you would basically be backing the labs into a corner, that every person would have to do things exactly the same way. And there are different manufacturers of gas chromatographs and things like that. So we wouldn't want to back everyone into that corner with saying this is the way every single test
But you
should be
could
handled.
say this is the way they should report it, and you should you should document when you can't test or not test or something like that. So you're not telling them what to do or how to do it, but just document it.
But that's
So that we
included
can
in the
look-
standard operating procedures, and we have no authority over the labs themselves. We only have authority over the analysts. And we approve the analysts, when they apply for a blood analyst permit, we review their standard operating procedures to make sure that their standard operating procedures are consistent with producing accurate and reliable
I
blood
gotta
test
say,
results.
this makes me feel very insecure about how much FDLE, and as it's pointed out, this is going into court on criminal convictions, how reliable these tests are, because if we can't regulate how they're collected, and we can't regulate what they do as far as standard operating procedures are concerned for documenting things, then I guess, are you saying that, obviously people make mistakes, when you're dealing with any kind of procedure topic, you can grab the wrong needle or in a medical setting give them the wrong drug or something like that. But if you don't document your mistakes.
Well, just every analyst is required to do proficiency testing twice a year, every year. So if they're making mistakes, we're going to see it in their proficiency testing, and would revoke their permit if they are making mistakes that would cause them not to pass their proficiency testing twice a year. So it's not that, and it's not that we don't have the authority to regulate. It's we only have the authority to regulate what affects the accuracy and reliability of the result. And as the record clearly indicates from the Division of Administrative Hearings hearing, things like clotting and hemolysis don't affect the accuracy and reliability of the result. And what is included in the blood collection in 11D 8.012, which was referred to as the blood collection rule, is that what affects the accuracy and reliability of the test result. And FDLE has the designated legislative authority to regulate that, only that affects the accuracy and reliability of the result.
Thank you.
Thank you. If there are no further questions, I'd ask this court, the department would rest on its brief and ask this court to affirm the decision of the administrative law judge.
Thank you.
Let me begin by reading Dr. Goldberger's testimony with regard to clotting. He absolutely testified that clotting does affect the accuracy and reliability of the result at page 297 of his testimony. But if you have clots, and he's talking about microclots, if you have clots that affect your ability to pipette the sample, those will affect the accuracy and reliability of the blood alcohol result. At page 337 of his testimony, this is a question, and ensuring that a clotted sample is not tested. That would go to the reliability and suitability of a sample for testing, correct? At page 338, yes. FDLE assumes that screening, documenting, and not testing a compromised sample is something that's not important. We know it's important. Why do we know it's important? Because in Palm Beach County, it doesn't happen. It doesn't happen because the Palm Beach Sheriff's Office testified that it doesn't happen. The deposition of Yateman was put into evidence in this case. The Palm Beach Sheriff's Office is the one who tested the appellant's blood here. And they testified that as a matter of course, they don't have to do those things, and sometimes they don't do it here. So it's extremely important that
When you say those things, are you talking
they
about
don't screen, they don't document, and they don't reject compromised samples. It's not unusual for them to pull out a clot from a sample. It's not unusual for them to test samples that have clots in them. It's not unusual for them not to document samples that have irregularities. So it's very important that there be rules that are enacted that require analysts to screen, to document, and to reject compromised samples.
Now, I guess your argument is that clotting per se is a compromised sample, and therefore if it's drawn and there's a clot, and even though they do the other things, the anticoagulants, the shaking, proper storing, etc., and when they test it, they try to take the blood that's not clotted, you're saying that all those, it's still not enough, that clotting per se?
There are versions of clotting, Your Honor. There can be microclots, as Dr. Goldberger testified. There can be clots that are so small that they cannot be seen with the naked eye. I recognize that. But Dr. Goldberger also testified, as I just read to you, that when a clotted sample, and he was very specific about clotted, a clotted sample should be rejected. And it is not us, and we did not propose in the court below what the rule should be, what the appropriate version of 8.012 should be, or what the appropriate version of 8.013 should be. That's up to the FDLE. But there needs to be a rule that regulates the appropriate type and size of the needle, that regulates that there should be no tubing, and that regulates the appropriate use of the tourniquet. There should be a rule that regulates the screening for irregularities, that regulates the documentation for irregularities, and that says that compromised samples should be rejected
All right,
and
so
excluded.
Counsel, to the extent that the department can regulate in this area, your belief is that this regulation is just inadequate.
It is inadequate.
Give you a accurate sample.
Yes, and might I also point out that the argument that was made by my opponent, that Miles did not say that the rule 8.012 was inadequate, that is exactly what Miles said. Miles held that 8.012 was inadequate and inconsistent with the purposes of the implied consent law. And that is exactly what we are saying, and also that 8.013 is inadequate and inconsistent. And let me end on that note and request that this court reverse. Thank you
very much. We will now take a recess for about 10 minutes.